So, good morning and welcome to The Box, which is Mills & Reeve's webinar series for insurers, intermediaries and their insurers. My name is James Thompson. I'm a Principal Associate in our Insurance Disputes Group, and I'm delighted to be joined this morning to talk about FCA regulatory investigations and coverage issues for brokers by my colleague, Rachel McDonnell. Morning, Rachel.
Hi, James. Thanks for the introduction. Good to see you all today, and I'm glad that we were able to overcome that technical hitch there. My name is Rachel McDonnell. I'm a Principal Associate in the Commercial Disputes Group at Mills & Reeve. I joined Mills & Reeve last year from a global law firm in London, where I spent around 50% of my time working on general commercial disputes and litigation, and the rest of the time working on financial services regulatory matters, which is what we're going to talk to you about today. So without any further ado, we'll just kick off and talk about what the overview of today's session will be. We're going to spend most of our time today talking about how regulatory issues might arise and whether the costs or other losses relating to those issues might be covered. And then we'll do a quick few minutes on other common questions that come up, including whether the costs of customer contact exercises and compensation payments might be covered, and also what about the costs of appeals. So what we're not going to be able to do today is flag every specific coverage or potential regulatory issue, but what we can do is identify some common themes. If you are interested in financial services regulatories more broadly, then please do take a look at our Regulate and Resolve seminars and sign up for invites. So financial services regulatory issues, now they're going to be a problem for, or could be a problem for, brokers or insurers or other intermediaries as regulated firms, or actually for their clients as well if they operate in the regulated financial services sector. These reg matters, they're often seen as very technical, and when they're identified, clients are understandably concerned about the impact on their businesses, the potential reputational consequences, and also there's all important scary fines. And often the first question I do get asked is when a new client comes to me is, is the FCA going to fine us? And I just want to start by saying that the reality is that in the very vast majority of cases, you are a long way off from formal enforcement action and all that might come with it, including any potential fines. That said, these matters really do need to be managed carefully to try and avoid that escalation by the regulator, usually the Financial Conduct Authority, the FCA. And often you'll need to be taking legal advice really early, and that can be a very expensive process, whether or not any formal action is ultimately taken by the FCA. Because right from the outset, what you're doing is looking to manage the process to avoid the need, or the FCA considering that it needs to take that formal enforcement action, which is why legal advice in these early stages is so important. I can say that I am regularly brought in after the horse is bolted, and that can make the job of convincing the FCA not to take further action much more difficult. So looking at the table on the screen, I think for these purposes, we can break down these potential regulatory issues and how they might arise into three main categories. And I'll give a bit of an overview of how these things might come up. And then James is going to talk about whether they might be covered, whether there might be cover available for them. So the first is self-reporting issues. And we gave a more detailed overview of self-reporting obligations in our recent Regulate and Resolve seminar. But for these purposes, it's probably enough to say that all regulated firms and senior managers who are themselves regulated have positive reporting obligations to disclose anything to the FCA or the other regulator of which they might reasonably expect notice, which is a pretty broad obligation and not very prescriptive. So in very broad terms, it means that if a firm or individual identifies a regulatory failing, then they may well need to go to the FCA and tell them about it. And this is seems quite counterintuitive, as it often triggers a train of inquiry and then legal expense involved in talking about how the issue has arisen and how it's going to be addressed, and then some work on how to address those problems going forwards and what to do with customers who may have been affected, for example. And that will always involve some legal and some other costs. So that's self-reporting, and you can see it on the slide there that we say, it's possible that these types of costs might be covered, but it's unlikely. Moving on to a general inquiry or request from a regulator. Often the FCA can ask questions of firms about practice or the way the business is operating, which can then lead to further questions or inquiries. They might have some concerns, not formal investigation, but actually just some questions that feel like they could be leading to some sort of criticism by the FCA, perhaps. Often firms can be asked to provide or required to provide documents by the FCA, even if those documents have nothing to do with any issues that the FCA has with the firm itself. So I've had matters where we spent 20, 30, more £1,000 dealing with requests from the regulator when actually that firm itself wasn't under scrutiny. And often, of course, they can be asked to attend interviews even where there's no investigation. So in terms of whether the costs of those activities might be covered, possibly under a D&O or a corporate liability policy, perhaps less likely professional indemnity. So that's general inquiries. And just to complete the picture, the third circumstance is a sort of full-blown enforcement investigation. And that will be an investigation by the FCA into firms or individuals. And the costs of that exercise can be really significant because an enforcement action follows a specific process that needs to be exhausted before it can conclude. It will be triggered by a formal notice. There'll be meetings with the FCA to scope the investigation, initial interviews, provision of many documents required by the FCA. I once had a matter with 20 tranches of different documents to deliver. Can be further interviews. And then typically only then will the FCA consider that it has sufficient information to reach a view on what its findings should be. And that's including penalties and settlements. And assuming that the firm or the individual doesn't want to fight that decision, then there's all sorts of things to be sorted out about what any public final notice might say or what the level of fine might be, and whether firms or individuals might be prevented from carrying on certain activities in the future. I mean, that's a whistle-stop tour. From beginning to end, it can be 1 to 2 years, and the costs can be well into the hundreds of thousands. And if a settlement can't be reached, then significantly more than that. And that's that is why it's so important to try and prevent moving into that enforcement investigation because of the costs and the process involved. And there you can see also on the slide we've said, yeah, again, this is probably going to be potentially covered under D&O or corporate liability policies, potentially professional indemnity. And James is just going to run through now in a bit more detail with reference to some example wording, why and how those circumstances might be covered.
Brilliant. Thanks, Rachel. So we will just skim through these sort of three categories. And just moving on to the next slide, I've put up there a sample professional indemnity wording, and I think the my sort of word of caution at the start is that all wordings will differ, and it is a question of knowing the wordings that you've got the benefit of. And here we think about self-reporting. I've put up this professional indemnity insuring clause, which explicitly provides defence costs cover for FCA investigations. But I think the question with self-reporting is whether or not an insuring clause is going to have been triggered. And you may have a distinction here between something that's occurred. You might have no notifiable circumstance under a policy, an obligation to notify your insurers, but you may not have a claim that has triggered the policy. And you may then have an obligation to undertake mitigation or reasonable mitigation steps. And you can see at the bottom of the slide, I've set out a mitigation clause. You must take all reasonable steps to avoid or reduce any loss that might arise. from any claim or circumstance. So that might be a positive obligation on you, and in the regulatory context, that may well involve self-reporting, but is the cost of that and the costs that flow from the self-reporting exercise going to constitute defence costs, which would be covered under the insuring clause that I've got up on the slide, or would there be mitigation costs that are very often excluded from cover? And again, it's a question of understanding the nature of your wording. Are mitigation costs covered or not? And something I've come back to a couple of times is know your wording, but also obtain a wording that's going to suit your needs, and think about yourselves as brokers, FCA regulated businesses. This stuff is a possible scenario that you might find yourself involved with. So at the point at which you are looking for cover, think about these situations and try and identify markets that will provide you with wording that's going to give you the necessary protection. If we move on and look at general inquiries from the regulator, well, on a sort of sliding scale, this may be one step beyond. And so, where in the self-reporting scenario, you might not have the trigger on the insuring clause, actually, a request or a full investigation from the FCA may well trigger cover, and so far more likely to get the benefit of defence costs, particularly here in this example where there is no ambiguity that FCA investigations will be covered. And again, other insuring clauses may well be less specific than the one I'm showing you here, more ambiguous. And it's the same point, trying to avoid the ambiguity by getting yourself a wording that is going to avoid any doubt or any argument with the insurer down the line. And in terms of how you practically deal with your insurer, it's a matter of I think having a good dialogue. So as early as you can when these situations arise, if there is any question mark as to whether or not the insuring clause is going to bite, have the dialogue either with your broker or with your insurer to try and get the benefit, and to ensure that insurers understand the nature of the situation that you're in. Moving to enforcement investigations, and I'm just going to move the slide on to look briefly at a D&O wording, because Rachel said at the outset that fines can be relatively rare, but if you look at this wording here, this insuring clause from this D&O policy, which provides we will pay civil fines and penalties, etc., etc. That may give you false comfort, because on a bare reading of the wording, you may think, oh, well, actually, in the situation where I get a fine from the FCA, then I'm going to be covered. But that's not the case, because if we look at this rule from the FCA Handbook GEN 6.1, no firm may enter into or arrange a claim or make a payment on contract insurance that is intended to indemnify people in respect of fines. They're uninsurable. And so even where you've got a wording that is ostensibly providing cover for a fine, that will not be enforceable pursuant to the rules under the FCA handbook. So that's a really important point here, that even where you've got the benefit of defence costs cover, be it under a professional indemnity or be it under your D&O or corporate liability wording, then the cost of the fine is not going to be covered. So Rachel, handing back to you.
Thanks, James.
My contacts.
Thanks. We just wanted to cover off finally a couple of common questions about coverage. And the first one relates to customer contact exercises. So sometimes underlying issues that have been identified relating to FCA activity can lead to claims against the firm or individuals, for that matter, by third parties. So obvious examples of this might be there's been a fraud and customers have suffered loss, or there's been some sort of mis-selling in which customers have also suffered losses that they need to be compensated for. And those claims, as you might think, might well be covered under a professional indemnity policy if those customers seek to make claims against the firm. But often where these issues have been identified by the FCA or with the FCA is going to expect firms to identify affected customers and actually go out and contact them proactively to establish whether they're entitled to compensation and then to pay that compensation. And the picture on whether those claims are covered is much less clear because firms are obviously making that approach. In one case I had, the FCA believed the client had been mis-selling complicated high-risk investments to unsophisticated customers. And actually in that case, the firm and its senior management individually were all in enforcement proceedings. In all honesty, the client was in a pretty bad position, and listening to the phone calls of the sales wasn't the prettiest experience. And in that case, the FCA had asked, as it often does, that the firm provide proposals on the scope of a customer contact exercise in order to compensate those customers who had made those investments and then suffered losses. And the challenge there was really that the client wanted the costs of the exercise, understandably, and any compensation payments to be covered by its professional indemnity insurance. But how to do that when the client was actively sort of going out to customers and seeking to pay that redress, even though the FCA had asked it to do so. And in that case, we were actually able to orchestrate a situation where the customer was asked to confirm various points that would give rise to a compensation claim. And the result was that we were able to bring the costs and the compensations within the ambit of the insurance cover. Now, of course, it is going to depend on the attitude of the insurer and the scope of the cover. And James, I didn't know if you had anything you wanted to add on that.
Yeah, I mean, just on that, Rachel, I think that there's obviously danger if you're trying to orchestrate a situation in which the policy is triggered, and obviously it's achievable in certain circumstances, but I think the message would always be tread very carefully to ensure that you're not taking any steps that are going to be sort of, equivalent to conceding liability or in any way sort of conniving with a potential customer claimant in such a way that plainly the insurance policy is not intended to provide support for that. So just take care, I think, is the health warning.
Yeah, I think that's right, and there's a sort of almost like a three-way dialogue to be had between the firm and the FCA, and then updating insurers on what the position is. Because if the FCA is saying to the firm, you must do this, that makes the conversation with the insurer slightly different, I think. I don't know if you'd agree, James.
Yeah, no, I would, absolutely. I think one of the key messages of all of this is that actually a dialogue is going to be really important to get the cover that you think you're entitled to.
Yeah. Okay, so that's customer contact exercise. And finally, the question on appeals and will the cost of appeals be covered? Now, this actually more often arises in the cases of individuals under investigation than firms, and there's a number of reasons for that. And some of those key reasons are that firms have often been for a very long enforcement action process. They're very keen to draw a line under what's happened and move on and get back to their business. They're possibly better able to saddle the fine that they might have to pay, and in addition, you get a discount if you settle early with the FCA, and there's a various stage discount approach. You can get up to 30% discount on your fine. So they're often quite keen just to sort of take the hit and move on, particularly because sometimes appeals in this context can be a bit of an uphill struggle. Individuals, on the other hand, perhaps this is often their livelihood on the line. They are going to have to pay fines themselves. It can be a significant amount of money to any individual, and they may well be, as part of their penalty, the FCA may be seeking to sort of prohibit them from carrying out their business going forward, which of course is very, very significant. So appeals often arises more broadly in the context of individuals. It will usually involve referring the matter to what's known as a regulatory decisions committee, which considers the case, and then either or referring the matter to an upper tribunal where there's a more adversarial hearing process, more like a civil trial. Needless to say, all fairly expensive when it comes to legal costs. And James, in terms of appeals, what do you think?
Yeah, I think that, it's almost like any civil claim where, if insurers are on the hook for defence costs, they're going to be competing views about the merits of how far you take something. And, you can well see a situation where if an appeal appears to be hopeless, insurers may well not wanting to be, continuing to fund that. So I think the question for the broker here, the policyholder, is understand what the dispute resolution mechanism is in the policy. If there is a dispute between insurer and policyholder, is it a QC clause which you have to go to arbitration? Just to understand how you would unlock that situation if the two parties can't agree on whether or not to fund an appeal.
Yeah, and I've certainly had cases in the past where a sort of a QC opinion where with reasonable prospects of success was required before the individual was able to appeal the FCA's findings. So that's a very quick walkthrough from us on coverage issues in financial services, regulatory matters, and I hope you found that helpful. I guess the key takeaway here and the themes that have come to the fore throughout the last 25 minutes or so is really to consider your policies early and whether cover might be available for these types of matters, to start that dialogue, and if issues do arise, to revisit the policies, notify and work with insurers to understand better the position.
Absolutely. And I don't know if we've had any questions whilst we've been speaking. Leanne?
Yes, we've got a couple here. So the first one is, you mentioned a self-report triggering a train of inquiry by the FCA. Could you give a little bit more of an idea of the costs that might be involved when making a self-report?
Sure, yeah, good question. So in terms of the costs of that process, they can be, they will vary depending on the type of issue that has been identified and how much work needs to be done to address it. But it's safe to say that in order to satisfy regulatory obligations, you need to give the FCA enough detail about the problem and how it's going to be addressed. So that means detailed reports and updates about what has happened, when and how it happened, the extent of the issue and what's going to be done about it. It also means thinking about the impact of that issue. So if there's been a problem over a period of time, how has that affected your customers? Could they have suffered any prejudice as a result of that issue? And if so, how are you going to make things right with them? And all those issues need working through, and you need to tell the FCA about it, regardless of whether the FCA sort of comes back and engages or asking questions. There's an inevitable cost to the business of that, involved with, legal costs, compensation costs, making changes to the business going forward. And yeah, the extent of the issue drives the extent of the costs.
Okay, thank you. And just one more, we've got time. What if you think you have cover under both a corporate liability and a professional indemnity policy?
Oh, difficult situation. And that is, I think, it comes up a lot because, very often you have situations where you actually, the insuring clauses and the kind of the sort of heads of cover will be very similar, and both policies could potentially bite. And the difficulty that you've got is that it is likely that both policies will contain an exclusion for losses that would be covered elsewhere. And so you have both insurers saying, sorry, not for me, which is a really difficult one to unpack, because I know sort of basic contractual analysis, both insurers may well be right about that, but it also can't be right that neither is entitled to indemnify. So I think very often in those situations where you reach that impasse, you then you get to the dispute resolution mechanism again. If there is you've got a dispute with both insurers, and then there will need to be probably a dialogue between both insurers, either to work out whether one or the other believes that they are one should be more likely to cover the particular loss or not, or whether there's going to be some sort of apportionment and a deal done between insurers. But that's a very plausible coverage dispute that could arise in the context of these sorts of regulatory investigations. Absolutely.
Okay, thank you. That's it then for the questions. Thank you.
Brilliant. Well, thank you very much, everybody, for joining us. Sorry about the sound issues right at the start, but we got through it. And I will leave you now to get on with the rest of your day in the sunshine. Thanks very much. Goodbye.